Good day, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk. Thanks for watching. We have a busy docket today, so let's get right to it. First, the circus continues in the Vallow and Daybell matter, and maybe the judge has just about had enough because he set a hearing. Second, Ghislaine Maxwell goes to court. Third, a fugitive is returned to prison after a 27-year jaunt. Fourth, this is why you want a zealous defense. Fifth, police officers intervene to stop an overzealous police officer. Sixth, another Parent of the Year contestant. And finally, our dumb criminal contestant of the day and a recap of all of our contestants throughout the week. Let's talk about it. Good day, Crime Talk aficionados. This is Crime Talk, and my name is Scott Reisch, the most fact-driven, unbiased, true crime channel. All right, we have a busy docket, so let's get right to it. But first, if you haven't done so, please hit that subscribe button as well as that little bell so that you receive notifications. We've had a lot of people say that they haven't been receiving notifications of when we go live or put up new content, so hit that little bell. All right, first on the docket. The circus continues in the Lori Vallow, Chad Daybell matter. And I think maybe the judge is just about getting tired and had enough, and he has set a hearing for April 28th. Now, how did this all come about? Was it perhaps maybe the judge was watching Crime Talk and said, hey, maybe that Scott Reisch knows what he's talking about, and I, as the judge, need to put my gavel down and make sure everybody knows I'm in charge, and let's set some dates. Well, we'll find out on April 28th, and we'll bring it to you live, but a lot of these seem to be happening in chambers, but hopefully it's held in public. But let's give you a recap. So yesterday, Mark Pryor filed a motion, and he is opposing the use of and a motion to preserve DNA samples. He also filed in this motion to photographic recording of serology samples and other visual tests, motions to review lab records. Well, what does this really mean? The district attorney put the defense on notice and said, hey, we are going to do some consumptive DNA testing. What does that mean? That means that the DNA samples that the lab people have been able to collect will be consumed in the testing, and therefore there won't be a sample for the defense to do independent testing. You may say, oh my gosh, this is outrageous. Why is the prosecution doing this? Are they trying to use up all the evidence so the defense cannot have their own independent expert? Not exactly the case. The point is DNA can be very small and very small amounts, and it can be consumed in testing. It's not uncommon when it comes to a lot of serology as well as DNA testing in the lab. What does that mean? Normally, the defense would like to have a sample so that they can have their own independent testing done. However, if it's consumptive testing, there can only be one test done. Is the judge somehow going to say you need to cut your sample in half and save half for the defense? No. What the judge will more than likely do in this particular situation is say, listen, Mr. District Attorney, Mr. Wood, what you're going to do is set a date certain for this testing to begin, and the defense, you can have your expert attend, and therefore they can observe all the cutting of the material where the DNA is going to be coming from, as well as the entire process to make sure that it is done in accordance with all the laboratory standards and procedures. Issue resolved. Happens all the time. I think the real issue is that the defense probably doesn't have an expert, and if they do, it's more than likely going to be expensive. And I can't imagine the attorneys are going to come up with this out of their own pocket, assuming their client doesn't have the financial wherewithal in which to pay the DNA expert. Now, the defense is also asking that all of the reports and what they refer to as bench notes be preserved. That's always done. And usually when you get a DNA packet, you get the bench notes so that you can have your expert review those bench notes to see if there's anything out of the ordinary. Now, Mr. Pryor filed the motion, but who could make it even more ridiculous? That's right, Mr. Means. So he files a motion stating that he is joining the motion filed by Mr. Pryor regarding the same issues. And then he goes into, and this is where it gets good, a copy of a midnight correspondence to counsel from the prosecutor in this matter. And what did he do? He had the audacity to CC, that's right, CC the court on this email as well. Now, Mr. Means then accuses the prosecutor of engaging in ex parte communications. What? How can it be ex parte if you are CC'd on the email? If the prosecutor was emailing the judge without your knowledge, that would be ex parte and completely improper. But the prosecutor doesn't do that. In fact, you can see that on the email. Anyway, Mr. Means goes on and says, it appears that the prosecutor is attempting to backdoor communications methods to potentially protect himself from a Brady violation. Finding of this court based upon the prosecutor's continual refusal to provide full and complete discovery responses, these direct, improper ex parte communications are potentially making this court an unnecessary witness in future litigation. What? He further goes on to say that he may seek relief from the court because of this unnecessary ex parte communication. I do not know where Mr. Means went to school, but clearly somebody has to explain to him what ex parte communications is. As you can see, it is a letter to Mr. Pryor. It's an email with a letter attached, and it has the court, Judge Boyce, and it has Mr. Means as well. That's not ex parte. So here's the letter. Take a look at this letter. Tell me if there is anything improper about this. I see nothing. It's a letter to Mr. Pryor, and it states, I'm including Judge Boyce and Mr. Means on this correspondence because I'm following up on the matter that you brought up during our recent conference on April 7th. You mentioned at the conference that you are estimating you are missing 30 items into discovery. The prosecutor then goes on to state, you've never told me what you're missing. You make these allegations, so we're following up. So the court ordered the prosecution to get them what they need to find out what is missing. As the prosecutor notes, I've given you everything except for Tammy Daybell's autopsy report, which the Fremont County prosecutor has not provided to him. Therefore, he can't provide it to the defense. The district attorney goes on to say, I'm a little surprised by your statement in court that you were missing such a large amount of items because we've basically checked and double checked and you've received everything. Now, this kind of goes along with the conversation that we had in yesterday's video. This is why the prosecutor is filing notices with the court on something that's usually done informally, because both the defense attorneys in this particular case have repeatedly accused the prosecutor of misconduct. He's just trying to cover his butt to make sure there is no appearance of impropriety. Now, Mr. Means, of course, follows up in this letter, and my God, somebody needs to get this man someone to proof his letters. And I understand we can all make mistakes when it comes to a typo. You get fast, you get lazy, but it seems to be a trend here. Here in this letter, Mr. Means states, I joint in Mr. Pryor's objection regarding consuming all remaining DNA samples and testing. Okay. And then he goes on to basically say, once again, painting a big overreaching broad brush, saying your office continually appears to have intentionally and wrongfully withheld this discoverable information / documents to date for unreasonable amount of time. Maybe you want to get a little spell checker and Grammarly. I highly recommend Grammarly. Don't get endorsed or anything like that, but it really helps you with your sentence structure. I do not understand why this attorney is always so overreaching. He has to be losing credibility with the court. You resolve discovery disputes informally. You request them, you put them in a letter, and when they tell you no, drop dead, we're not doing it, then you go to the court. So now we have a court that can't seem to get anything done because everybody's fighting and bickering over discovery. This sounds more like a civil case, which maybe some of the attorneys are more inclined to do and be, than a criminal defense attorney, which is simply, let's go try this case and let's get it over with. The circus continues, ladies and gentlemen. All right. Next on the docket, Ghislaine Maxwell goes to court. And, Ghislaine Maxwell has been in custody since July 2nd of 2020. She went back to court to enter a plea of not guilty to the superseding indictment, which alleges one more additional victim in addition to the 3 victims that have already been named in the indictment. The prosecutors believe that the defense shouldn't have any trouble trying to be prepared for the July 12th trial date, and the defense says they're going to need more time because of the new charge. The court hasn't ruled, but they didn't seem inclined to grant a continuance, and if there's going to be a continuance, it will not be a lengthy continuance. We'll continue to follow this case. This case is one that needs to go to trial. Next on the docket, a prisoner, a fugitive, is returned to justice after 27 years on a little jaunt. Samuel Avalos Gallardo, 52, was discovered living in Mexico and was arrested back in January of 2020. After a lengthy extradition process, he is now back in the care and custody of the Nevada Department of Corrections. Mr. Gallardo had been sentenced to 40 years in jail when he drove his car the wrong way down a road while drunk on an interstate, colliding with another vehicle and killing an 18-year-old driver in the other vehicle. This was back in 1992. He was sentenced to that 40-year term in 1994. Mr. Gallardo was only a few months into his sentence back in 1994 when he walked away on a work crew when he was working for the Division of Forestry on a fire crew. Just remember, ladies and gentlemen, the long arm of justice will find you, and there is someone always working those cold cases, even if it's an escaped prisoner. Now, I also know that Mr. Gallardo was living in Mexico. However, it makes you wonder, do you really know with whom you are dealing with? All right, let's take a quick recess. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did. Next on the docket, this is why you want every defendant to receive a zealous defense. James Davis has been in custody for nearly 17 years, and his case has worked through the system because he claims that he is being held in custody for a murder that he did not commit. He states, and the appellate courts agreed, that he gave his attorney the names of 6 people who attended a party where the shooting occurred and that they would support his alibi. Mr. Davis states that his then attorney, a gentleman by the name of Joel Meadows, did not contact 5 of the 6 of those people, and they are sure that he would not have been convicted if he had done so. Guess what? The appellate courts agree, and Mr. Davis is getting a new trial. Yes, I know everybody wants to rush a defendant to trial, and sometimes that's a good tactical advantage. And cases, if they are being worked diligently, can be done quickly so that everyone has a fair day in court. But you must give the defense the resources to go and investigate a case so that justice is done. Mr. Davis will get a new trial. They'll decide whether he's been wrongfully accused, convicted, and held in custody for the last 17 years, or whether he is the person who actually committed the crime. Wouldn't it have been a lot easier just to make sure that he had a proper defense 17 years ago? Now take a look at this video here on the docket. A Westminster police officer was seen punching a woman as she was placed in custody. She looked like she was resisting. The officer then punched her in the face twice. Now, at this point, the other officers are heard saying no, and they get in between the officer that was doing the punching.
¿Qué hizo?
Mira. No. Hey, stop. Grábalo bien, grábalo. Grábalo, mira ya.
¿Ya vieron?
Ya lo están grabando. Y a ese que pegó, mira.
This is what is supposed to take place. Nearly every law enforcement agency in the country has rules and policies that if one officer sees another officer exercising excessive force, that they are supposed to report it and at a minimum attempt to stop it. These cops did it the right way, which confirms, yes, there are good cops out there. They just can't continue to protect the bad apples. And hopefully in this particular case, this bad apple has to go find a new job. Next on the docket, another Parent of the Year contestant. Christina Clark Wilcox is charged with the death of her daughter, Paris. She was found unresponsive and not breathing at her mother's home back in July. Well, it turns out if you consume fentanyl, which the child had done, that the mother left laying around, it could in fact kill you. And in this particular case, a grand jury has returned an indictment alleging aggravated child neglect and aggravated child endangerment. Ms. Wilcox turned herself into custody, and we will see if she can make her $250,000 bond. All right, ladies and gentlemen, first, our dumb criminal contestant of the day, and then a quick recap. Although today's contestant, he has got to be a leader for sure. Meet Robert Chapman. He apparently was at the Capitol for the January 6th riot. And he apparently was pretty proud of that fact. He also thought that maybe all the women in his world would totally dig that. So when he was on Bumble making arrangements to meet a date, he basically admitted that he stormed the Capitol. He made it all the way to Statutory Hall, and he did an interview with the Washington Post. Guess what? The woman responded back, "We are not a match," and notified the authorities that Mr. Chapman was at the Capitol, which has resulted in his arrest. Now, Mr. Chapman, we're not going to get into the whole Capitol thing, but if you do, in fact, commit a crime, general rule of thumb, don't brag about it, particularly don't brag about it to others where it's documented and it can actually be used against you. So for that, Mr. Chapman, you are our dumb criminal contestant of the day. And I have to say, you may be the leading contestant. All right, now a recap of our dumb criminal contestants throughout the week. First, Monday, Cordell Coleman, 33, Arkansas. Just moments after being released from custody for public intoxication, Mr. Coleman drove away from the jail, that's right, in a Little Rock police officer's SUV that was all caught on video. Tuesday, Michael Holden, facing multiple charges for a break-in 90 miles north of Pittsburgh. He went into a home of an acquaintance, stole $700 in cash, various bank cards, and he also stole the woman's sex toys, valued at $160. He ultimately did say that he went into the residence, but he was just picked up a couple of things along the way. Yep, gonna be guilty. Wednesday, Michelle Stillwell, while riding in the back of an Uber, attacked the Uber driver, choking him and biting his neck, and once again, all captured on video. Thursday, the North Carolina man, Jamichael Walton, 30, was running away from police officers who was responding to a property damage call. Walton was charged with threatening to kill the mother of his brother's child, and after being handcuffed and placed in the squad car, he threatened, "When I get out, I'm going to shoot up this car and you all." He was hit with a fourth charge, felony of possession of cocaine, because you may notice a little spot under his nose right there of little cocaine right there, a little spot right there. Yeah. And then obviously today, Mr. Chapman, our stormer of the Capitol, who brags about it on Bumble to his future dates, and they turn him in. Congratulations. You may not win the Dumb Criminal Contestant of the Week, but you are all winners in your own right. Only one can be the true winner. And what does the true winner receive? That's right, Crime Talk gear. Now, if you would like to have Crime Talk gear without having to become a Dumb Criminal Contestant, simply hit the link below. You can go check out all the gear, cool stuff, click on it, bam, next thing you know, you have your own Crime Talk stuff. Send us a picture of you with your Crime Talk gear. We will put it up on our Instagram and Facebook sites. All right, thanks for watching. I hope you all had a great week. Have a wonderful and safe weekend, and we'll see you next week on Crime Talk.